Welcome to Literary and Jury Charge Practice. We'll start out with some jury charge. Ready? Here we go. When I ordered that testimony be stricken from the record, you may not consider that testimony during your deliberations. Also, if any testimony was received for a limited purpose, you must follow the limiting instructions I have given and use the evidence only for the purpose I indicated. The only exhibits that are evidence in this case are those that were received in evidence. Exhibits marked for identification but not admitted are not evidence, nor are materials that were used only to refresh a witness's recollection. Witnesses sometimes have a failure of recollection when testifying. In such circumstances, it is proper for the lawyer questioning the witness to attempt to refresh his or her recollection. As I told you during the trial, anything can be used to refresh a witness's recollection. Where a document is used, that document does not have to have been prepared by the witness, made contemporaneously with the events described in it, or be admissible. Where a witness states that a writing has refreshed the witness's memory, then the witness may proceed to testify as to the matters on which his or her memory was refreshed. That testimony is evidence. However, where a witness states that his recollection is not refreshed, any statements a lawyer may have made about the document used in the attempt to refresh the witness's recollection are not evidence. As I told you at the start of this case, arguments by lawyers are likewise not evidence because the lawyers are not witnesses. What they have said to you in their opening statements and in their closing arguments is intended to help you understand the evidence to reach your verdict. However, where your recollection of the evidence differs from what a lawyer has argued, it is your recollection of the evidence that controls. You must determine the facts based solely on the evidence received in this trial. In determining the facts, you must rely upon your own recollection of the evidence. Where the lawyers said in opening statements, in closing arguments, in objections, or in questions is not evidence. I remind you also that nothing I have said during the trial or will say during these instructions is evidence. Similarly, the rulings I have made during the trial are not any indication of my views of what your decision should be. It is for you alone to decide the weight, if any, to be given to your testimony you have heard and the exhibits you have seen. Generally, there are two types of evidence that you may consider in reaching your verdict: direct evidence and circumstantial evidence. Direct evidence is testimony by a witness about something he or she knows by virtue of his or her own senses, something seen, felt, touched, or heard. For example, if a witness testified that when he left his house this morning it was raining, that would be direct evidence about the weather. Direct evidence may also be in the form of an exhibit. Circumstantial evidence is evidence from which you may infer the existence of certain facts. For example, assume that when you came into the courthouse this morning, the sun was shining and it was a nice day. Assume that the courtroom blinds were drawn and you could not look outside. As you were sitting here, someone walked in with an umbrella which was dripping wet. Then, a few minutes later, another person entered with a wet raincoat. Now, you cannot look outside of the courtroom and you cannot see whether or not it is raining, so you have no direct evidence of that fact. But on the combination of facts that I have asked you to assume, you could conclude that it had been raining. That is all there is to circumstantial evidence. On the basis of reason, life experience, and common sense, you infer from one established fact the existence or non-existence of some other fact. The matter of drawing inferences from facts and evidence is not a matter of guesswork or speculation. An inference is a logical, factual conclusion that you might reasonably draw from other facts that have been proven. Many material facts, such as what a person was thinking or intending, are rarely easily proven by direct evidence. Often such facts are established by circumstantial evidence. Circumstantial evidence may be given much weight as direct evidence. The law makes no distinction between direct and circumstantial evidence, but simply requires that before convicting a defendant, the jury must be satisfied of the defendant's guilt beyond a reasonable doubt based on all the evidence in the case, circumstantial and direct. There are times when different inferences may be drawn from the evidence. The government may ask you to draw one set of inferences, while the defendant asks you to draw another. It is for you and for you alone to decide what inferences you will draw. What is important here is the quality and persuasiveness of the evidence relied on by a party, and not the number of witnesses, the number or variety of the exhibits that party introduced, or the length of time that party spent on a particular subject. You should draw no inference or conclusion for or against either side based on a lawyer's objection or my ruling on the objection. A lawyer has an obligation to object when he or she believes that evidence is not properly admitted under the rules of evidence. You should likewise draw no inference or conclusion of any kind, whether favorable or unfavorable, with respect to any witness or party in the case, by reason of any question I posed to a witness. There is no legal requirement that the government prove its case through any particular means. You are not to speculate as to why the government used the techniques it did, or why it did not use other techniques. Law enforcement techniques are not your concern. Your concern is to determine whether or not, based on the evidence or lack of evidence, Mr. Martoma's guilt has been proven beyond a reasonable doubt. You should evaluate the credibility, believability, and reliability of the witnesses by using your common sense. Common sense is your greatest asset as a juror. Ask yourself whether the witness appeared honest, open, candid, and reliable. Did the witness appear evasive or as though he or she was trying to hide something? How responsive was the witness to the questions asked on direct examination in comparison to the questions posed on cross-examination? You should also consider the witness's ability to recollect past events. If you find that any witness has lied under oath at this trial, you should view the testimony of that witness cautiously and weigh it with great care. It is, however, for you to decide how much of the witness's testimony, if any, you wish to believe. Few people recall every detail of every event precisely the same way. A witness may be inaccurate, contradictory, or even untruthful in some respects, and yet entirely believable and truthful in other respects. It is for you to determine whether such inconsistencies are significant or inconsequential, and whether to accept or reject all, or to accept some and reject the balance of that witness's testimony. All right, now we'll try. Take a little rest. I know that was a long stretch. Good practice. Next, we will practice some literary material. And this is one we had started previously called New Twists on Deductibles. Okay, ready? Here we go. Percentage deductibles. These deductibles have been the norm in Texas for a while and are becoming more common elsewhere in the country. Rather than being set at a flat dollar amount, the deductible is stated as a percentage, typically 1 or 2% of your dwelling coverage, or the amount your policy states you'd need to completely rebuild your house, not including replacing the contents. So if your dwelling coverage is $300,000 and your deductible is 1%, you'd pay the first $3,000 of any repair. Percentage deductibles often require one to pay more out of pocket than flat dollar amount deductibles, but they also typically come with a lower premium. How do I choose the right deductible? With these new options, it can be hard to know which type of deductible is best for you. In general, insurance is meant to protect you from big losses, not cover the little things you can afford to fix yourself, which is why some people choose a higher deductible. If you decide to go that route, keep in mind that you'll retain more of the claim cost if something substantial happens to your house. In other words, if your deductible is $3,000, you'll need to come up with that amount if you experience a significant loss. Whatever you do, always carefully read through your policy, including your renewal packet when it comes each year. If you have any questions, talk to your insurance agent. Better to take time now to clarify your coverage than be surprised later. All right, we'll get back to some jury charge practice. Ready? Here we go. In sum, it is up to you to decide whether the testimony of a witness is truthful and accurate, in part, in whole, or not at all, as well as what weight, if any, to give to that witness's testimony. In evaluating the testimony of any witness, you may consider, among other things, the witness's intelligence, the ability and opportunity the witness had to see, hear, or know the things that the witness testified about, the witness's memory, any interest, bias, or prejudice the witness may have, the manner of the witness while testifying, and the reasonableness of the witness's testimony in light of all the evidence in the case. The government is not required to prove the essential elements of the offense by any particular number of witnesses. The testimony of a single witness may be sufficient to convince you beyond a reasonable doubt of the existence of the essential elements of the offense you are considering, if you believe that the witness has truthfully and accurately related what he or she has told you. You have heard argument that at some earlier time witnesses said or did something that is inconsistent with their trial testimony. Evidence of prior inconsistent statements was introduced for the purpose of helping you decide whether to believe a witness's testimony. If you find that a witness made an earlier statement that conflicts with the witness's trial testimony, you may consider that fact in deciding how much of the witness's trial testimony, if any, to believe. In making this determination, you may consider whether the witness intentionally made a false statement or whether it was an innocent mistake, whether the inconsistency concerns an important fact or whether it had to do with an insignificant detail, whether the witness had an explanation for the inconsistency, and whether that explanation accords with your common sense. It is exclusively your duty, based upon all the evidence and your own good judgment, to determine whether the prior statement was inconsistent, and if so, how much, if any, weight to give to the inconsistent statement, in determining whether to believe all, part of, or none of the witness's testimony. In deciding whether to believe a witness, you should consider whether there is any evidence that the witness is biased in favor or against one side or the other. Likewise, you should consider evidence of any other interest or motive that the witness may have in cooperating with a particular party. You should also take into account any evidence of any benefit that a witness may receive from the outcome of the case. It is your duty to consider whether any witness has permitted bias or interest to color his or her testimony. If you find that a witness is biased, you should view his or her testimony with caution, weigh it with great care, and subject it to close and searching scrutiny. Of course, the mere fact that a witness has an interest in the outcome of this case does not mean he or she has not told the truth. It is for you to decide from your observations and, applying your common sense, life experience, and all the other considerations I have mentioned, whether the possible interest of a witness has, intentionally or otherwise, colored or distorted his or her testimony. You are not required to disbelieve an interested witness. You may accept as much of his or her testimony as you deem reliable and reject as much as you deem unworthy of acceptance. Dr. Sidney Gilman and Dr. Joel Ross were witnesses in this case. Both testified that they entered into non-prosecution agreements with the government. In exchange for the government's agreement not to prosecute them, Dr. Gilman and Dr. Ross agreed to cooperate with the government, including by testifying at this trial. You are not to draw any conclusions or inferences of any kind about the guilt of Mr. Martoma merely from the fact that Dr. Gilman and Dr. Ross entered into non-prosecution agreements with the government. Dr. Gilman and Dr. Ross made a personal decision to cooperate with the government based on their own evaluation of the facts and circumstances. Their decision to cooperate with the government is not evidence that Mr. Martoma committed a crime. A defendant may not be found guilty simply based on his association with individuals who decided to enter into non-prosecution agreements with the government. All right, we will stop there. Get back to this jury charge later. We'll try a little more literary practice. Ready? Here we go. Start again. Ready? Here we go. Flooring It, a visitor's guide to the souped-up Petersen Automotive Museum. When a car is restored to better than new condition, it's said to be cherry. Well, welcome to the most cherry museum in Los Angeles, self-proclaimed car capital of the world. It's the Petersen Automotive Museum, fresh off of a $90 million renovation with an exterior newly clad in stainless steel ribbons that suggest the dynamic motion of what's inside. The Petersen hosts a world-class collection of exotic cars, many of them famous from film and television. Founded in 1994 by Robert Petersen, whose publishing empire started with Hot Rod magazine in 1948, The museum was built in what was originally a boxy department store. Today it anchors Wilshire Boulevard's Museum Row, just steps away from the La Brea tar pits. In addition, the museum plans to rotate exhibits and sponsor frequent movie nights and car shows. We want people to say, "It's been 6 months since my last visit. Let's go see what's new," says Chairman Peter Mullen. All right, that will conclude our literary and jury charge practice.